Good afternoon and welcome to the Appellate Division. We have almost 7 hours of argument time requested and a number of complicated cases today, so only ask for the time that you need, not the time that you wish. We are familiar with the briefs and the records. If we have further questions, we will definitely keep asking them. People versus Ortega, submitted. Matter of Estate of Kendall, Granville Chen, appellant? Respondent? I'm going to give you 6, 1, and 6. E. Lennox is submitted. Felipe versus City of New York. I know that the appellant is not here. I'm sorry, the respondent is not here. The two appellants are here. Do you want to submit?
Unless the court has any questions on that, please.
Okay. Do you want 2 minutes too then? Sure. Okay. 2 and 2. There's 2 Judlow cases. I'm going to do them separately because there's different counsel on each of them and different issues. Herman versus Judlow Contracting, appellant? Respondent? 5, 2, and 6. Judlow Contracting versus City of New York, appellant? Respondent? 5, 2, and 5. People versus Navarro is submitted. Plumbers Local Union versus New York City Department of Buildings, appellant? Respondent?
6 minutes to respond.
6, 1, and 6. Bago versus La Brochette, appellant? Are you respondent or appellant? Do you wish to submit?
Unless the court has questions.
No. It's submitted. Nicholas Industries versus Nasdi, appellant? Do you want rebuttal time too?
Yes, 2 minutes rebuttal.
Respondent? 6, 1, and 6. Bailey versus 2732 Bainbridge Associates, appellant?
5 and 2, please.
Respondent? 5, 1, and 5. Deaton versus Ruckus 85 Corp., appellant?
Good afternoon, for appellant 4 and 2, please.
Respondent?
Good afternoon, Your Honor, for respondent Ruckus, 6 minutes.
4, 2, and 6. I'm sorry, what?
Second respondent.
Sorry.
Raven Walker, 3 minutes.
I'll give you 2. State of New York versus Kenneth W., appellant? Respondent? 6, 1, and 6. Thoroughbird Grand versus M. Melnick, appellant?
Appellate 5 and 1, Your Honor.
Respondent?
Good afternoon, Your Honor,
5, 1, and 5. People versus Dwight Furrett, appellant? Respondent?
6, Your Honor.
I'll give you 5, 1, and 5. Epps versus Barfield Realty Corp., appellant? Are you appellant or respondent? Okay, it is submitted. Henry versus Tower Group is submitted, and Metropolis Electric Corp. versus Vector Building is submitted, and Barksdale versus Honorable Lippman is submitted. So our first case will be Matter of Estate of Kendall Granville Chen.
Good afternoon, Your Honors. May it please the court, I'm Lloyd Clareman for the appellant.
Maybe you could put the microphone by you.
that okay there?
That's better.
Okay, thank you. I'm Lloyd Claremont for appellants Kimball Chen and Catherine Zickerman as trustees of the C.Y. Chen Trust. Your Honors, in New York, under New York law, a trustee cannot divert for his personal benefit trust fund distributions that were intended for the beneficiaries and still be entitled to retain his trustee commissions.
Did you make that exact argument below about the faithless servant doctrine?
The argument was not presented. I was not counsel in the court below. I came into this case when it went up on appeal.
It wasn't made below. Why should we address it now?
Because, Your Honor, and I think it's a critical point, because even though the legal theory of faithless servant was not presented to the court by that name, and the cases that I cite as the faithless servant cases, which are the operative legal theory in this case, were not cited, counsel below did put in the petition that he filed, in the brief that he filed, and argued to the court all of the facts that support the application of the theory and requested the very remedy that the theory provides, which is the return of Kendall's compensation.
And why shouldn't the settlement agreement bind the petitioners in this matter?
For the very simple reason, Your Honor, which the estate admits on page 27 of its brief, the settlement agreement does not bind the trust, and it is not signed by the trust.
Did your client even know that there was a negotiation or settlement going on between the other brother and his children?
I think the answer to that is yes, Your Honor, that he was aware that they had retained counsel and that there were negotiations going on, so the answer is yes, but he was not included in the negotiations. The estate was not.
Never
I'm sorry,
signed. He never signed on to the
He
agreement.
never signed it. There's no signature line provided for him, so he was not in any sense, the trust was not bound by that settlement agreement.
Counsel, the issue of ratification, the fact that that Kimball, your client, allowed Kendall to be paid commissions in 2017 and 2018, they both agreed not to be paid in 2016. Is that somehow a retroactive ratification of a sort or not?
I submit that it is not, Your Honor, and the reason is it was a very complicated situation, needless to say, between brothers in the same family, and it involved the children of the family, nieces and nephews and children. And so in 2017 and 2018, when Kendall had ostensibly paid his children the money that he diverted and remained as trustee, Kimball's only ability, Kimball and Catherine, Kimball at that time, Kimball's only ability to not have Kendall paid would be to sue him and have him removed as a trustee, and that's a pretty consequential thing to do. And so I would submit that the issue of ratification falls right into something that was discussed in the Adelphia and Carmona cases. Kimball's actions reflected the complexity of the situation and not an intent to retroactively ratify the commissions that Kendall received when he was acting in extreme disloyalty to the trust. And most of all, Your Honor, it's an issue of intent. And therefore, on a motion to dismiss, I don't see how the court can reasonably get there when intent is so intrinsically inferential.
Thank you.
Thank you. I want to address very quickly this notion that Kendall was not acting in a trust capacity, or his capacity as a trustee, and that whatever wrongdoing he did somehow was individual and therefore didn't constitute a breach of his duty to the trust. The trust indenture, the trust instrument itself, I think it's page 36 of the record on appeal, provides that distributions are to be for the benefit of, or paid to, or for the, applied for the benefit of the beneficiaries, of course. So Kendall violated, through this scheme that he orchestrated, which was not just the final step of removing money from the joint account, but the orchestration of a scheme where, as alleged in the petition, he concealed the existence of the trust from the children, he concealed the distributions from the children, he concealed the joint accounts from the children. It was all part of a scheme to divert their distributions. The most fundamental violation of his core fiduciary duty that one can imagine. So the statement that it was not a trustee action was made in the context of Kimball's former lawyer saying Kimball was not complicit in that. It was not in the context of saying that Kendall was entitled to retain
you.
his compensation. Thank you, Your Honor.
Officer, could we have someone at some point look at the microphone? What? Oh, you're here. Okay. Yes, yes, okay.
I apologize, Your Honor.
No, that's not you. Something's wrong with the microphone. They need to take a look at it. Oh. But you'll have to go on with the broken microphone.
I will do my best, Your Honors. Good afternoon. Brett Kahn, Farrell Fritz, for the respondent, the estate of Kendall Granville Chen. Your Honors, the surrogate of New York County dismissed claimant's petition for 4 separate reasons.
Counsel, why don't you focus on the faithless servant, since that seems to be the primary argument on appeal? And I know that it was not argued below, or not directly, but why isn't that a viable argument, the faithless servant doctrine, as a basis for disgorging the commissions?
Of course, Your Honor. As appellant has conceded, it was not raised below, and thus our position is that it is not preserved for appellate review.
Okay, but assuming that we are going to address it, and I'll let you then argue why we shouldn't, but assuming we're going to address it, what's your substantive response to why it's not dispositive to support a reversal in this case?
Well, Your Honor, they are conflating faithless servant with breach of fiduciary duty. And
Isn't it a subsection of breach of fiduciary duty? And that's part of why maybe it is preserved. Isn't there an argument to be made that it's just a subset of breaching your fiduciary duty? If you're a faithless servant, you a priori, you're breaching your fiduciary duty.
no, Your Honor, they're distinct in 2 ways. One, for a successful breach of fiduciary duty claim, there needs to be a fiduciary. And the faithless servant
So why
doctrine
wouldn't there be
typically...
a breach of fiduciary duty to the trust here?
Could you repeat that, Your Honor?
Why wouldn't there be a breach of fiduciary duty to the trust?
There was no damages to the trust, as the surrogate ruled several
Well,
times, because
if you collected commissions that you weren't entitled to, isn't that a damage?
the commissions were paid out as he did his responsibilities as trustee for very many years.
Right, but counsel, isn't that exactly the point, that if he was taking commissions for many, many years, while he was clearly not carrying out his duties because he was diverting the trust funds from his children for his own purposes, why wouldn't that be a breach of his fiduciary duty as a trustee to act as the trust had been set up to be enacted?
Well, Your Honor, we respectfully submit that the joint accounts were not created until 2011, and any alleged wrongdoing occurred once money was properly transferred out of the trust, and
Is there any dispute that he took money that was intended to be for his children pursuant to the trust and used them for his own purposes? Is there any dispute about that? During the time of the trust? I mean, wasn't that the whole basis of the settlement agreement?
that was, Your Honor.
So that being the case, if that's undisputed, why wouldn't that behavior, however it exactly got played out, be a basis for asserting a breach of fiduciary duty claim?
The only parties that were harmed the decedent's children were made whole through the settlement agreement. And for,
What about the brother's children? They were also supposed to be beneficiaries of this trust, weren't they?
they properly received their distributions, Your Honor.
Isn't there a harm in paying the commissions? If he was taking commissions for many years while he was not carrying out his duties, isn't that a separate and distinct harm from any harm that's alleged in terms of the actual distributions? That if he was a faithless servant and breaching his fiduciary duty, then the argument could clearly be made that he had no right to recover those commissions, and the harm to the trust would then be that they paid those commissions to him for years when he didn't have a right to have them.
Your Honor, the trust was not damaged, and to
But
the
he
extent
didn't
that
carry out what his duties were in terms of the trust.
there was no allegations that he didn't carry out his duties, such as paying taxes, prudently
Well, no,
investing.
why isn't part of the duty is to carry out the purpose of the trust? If the purpose of the trust was to distribute the money to his children, and you've just conceded that he didn't distribute the money to his children, why isn't that a failure to carry out his duties? And why isn't the damage the commissions he was paid, which should then be disgorged?
Your Honor, I apologize. I did not concede that the distributions were not made. The distributions were properly made from the trust. Claimant Kimball's own counsel said that those distributions were not trustee actions, as did Kendall's
The
children who...
distributions are made, but then he takes what's been distributed and takes it for himself, which is not the purpose of the trust.
Your Honor, the trust existed since 1983. The only time that there were allegations of wrongdoing were from 2011 to 2016, and the only parties that were harmed were made whole through the settlement agreement. As the surrogate correctly held, Your Honor, the trust was not harmed. And
You
therefore-
haven't addressed why the payment of commissions when there was a breach is not a harm. Alleged breach of fiduciary duty was not a harm to the trust.
Commissions to the two beneficiaries that are not parties to the settlement agreement. Commissions are a trustee's statutory right for doing the job as
He's
trustee.
doing
which
what
he
he's
has-
if he's doing what he's supposed to be doing, but he was supposed to be using these funds for the benefit of the grandchildren or his children, and instead he takes those funds for himself. So he's not doing what he was supposed to be doing as a trustee.
But he properly administered the trust, Your Honor. Those distributions were made from the trust to joint accounts. That trust existed for decades
Under the
before any
faith-
allegations.
Under the faithless servant doctrine, I thought no damage need be proven under the prevailing law. Even if that's not the case, you still, faithless servant doctrine will still be operative.
And Your Honor, we respectfully submit that's why that argument should not be considered. If faithless servant was in the record below, we would have submitted different evidence and made different legal arguments.
Thank you.
Prejudicial.
Thank you.
Thank you, Your Honor.
Your Honors, briefly in response, faithless servant is indeed a subset, a variant, a subtype of breach of fiduciary duty. It provides a special remedy where a fiduciary has been faithless, a special remedy that doesn't look to the question of whether the principal, in this case the trust, was harmed or not. Doesn't matter. It looks to compensation forfeiture. And importantly, that's exactly what counsel below asked for as the remedy, compensation forfeiture. Basically, alleged everything concerning faithless servant without calling it by name. And there are multiple Court of Appeals cases which I've cited, which this court is well familiar with, that on a motion to dismiss, the question is not whether the plaintiff has artfully stated a cause of action, but whether he hasn't.
Thank you very much.
Thank you, Your Honor.
Felipe versus City of New York.
Your Honors, may it please the court, my name is Amanda Abacha and I represent the city appellants. I just briefly want to say in sum that this court should reverse the lower court's decision Philippe's affidavit was insufficient to sustain this action. It was based on hearsay, it lacked personal knowledge, and in any event, it failed to make out a prima facie case for the city's negligence, a fact that they effectively concede by asking this court to utilize the noseworthy doctrine, which doesn't apply here. So therefore, the court should reverse.
Thank you.
Unless you have any questions.
No questions,
Thank you so much.
unless anyone had a question.
Good afternoon. May it please the court, Christopher Kenoy for the Appellant Volunteers of America. I agree with what co-counsel has said here. I will note that there is a case in our brief that is directly on point here in the First Department at a foyer versus, incidentally, Volunteers of America, which says exactly what we've been arguing.
Really not hard to distinguish facts in this case from the facts in that case, right?
I don't think so, no. And absence of a proper affidavit of merit is a death blow to plaintiff's case, and it's unfortunately as simple as that. Unless your honors have any questions, I'll rest on my submissions.
Thank you very much.
Thank you.
Herman versus Judelau Contracting.
Good afternoon, and may it please the court. Brianna S. Walsh of Pillsbury, Winthrop, Shaw, and Pittman on behalf of defendant appellant Jude Law Contracting. In its simplest form, the question before this court today is whether a $43.9 million judgment can stand in the absence of any proof of the work that the plaintiffs were doing.
Well, what effect does our prior appellate decision have on that determination? I mean, aren't we sort of past a lot of those steps now because of our prior affirmance of the prior decision by Judge Barak?
So the the 2022 decision by this court dealt with summary judgment on liability only. It did not deal with the scope of damages. That issue is left for the referee at a hearing. When you go to the
One of the primary arguments you're making on this appeal is that not all the work that plaintiffs did constituted prevailing wage work. But didn't the lower court specifically address that argument on the summary judgment motion, and didn't we previously address that on the appeal? We found all the work did constitute prevailing wage work because it involved the protection of the public safety near a construction site. So isn't that issue off the table at this point, that argument, based on both the lower court summary judgment decision and our affirmance of it?
I don't believe so, Your Honor. The prior finding wasn't that all of the work was prevailing wage work entitled to here what was $94 an hour. It was that some of the work that plaintiffs performed was consistent with the type of work that qualifies for prevailing wages, and therefore they might be entitled to those wages. When we get to the damages hearing, plaintiffs offer...
Is it your argument that there's been a failure to establish what portion of the work is prevailing wage work and what work does not fall under those requirements?
Yes, there is a total failure of proof with respect to whether or not the plaintiffs were conducting prevailing wage work or non-prevailing wage work, for example, standing down the block from a construction site and merely flagging pedestrians and telling them you can't go down here, there's construction. That's different, and it's compensated differently than a flagger who is actually on the site. And if you look at the record, you'll find no proof regarding what any of these plaintiffs did at any given time. What the referee ended up doing is choosing to apply the local 731 rate, which is a skilled trade rate for workers who engage in heavy excavation and underground work at $94 an hour. There's no logical explanation for awarding that without any proof as to what those plaintiffs were doing. The only testimony at the damages hearing was plaintiff's expert, Mr. Nodell, who agrees with us. He says, if a worker is flagging on or about a job site or working around the perimeter of that job site or physically on that job site, that is prevailing wage work. But if a person is a block away telling traffic they can go down a street because it's closed off, that's not a prevailing wage issue. We don't know on this record what any of these plaintiffs were doing and if they're entitled to work. And I think the issue that people keep conflating is total hours worked with total hours worked on a prevailing wage task. If plaintiffs prove that they were on a job site within the construction zone and therefore entitled to prevailing wages, it would be a different conversation, but they didn't. They offered no proof at all as to what their day-to-day activities were. So all we have here is a massive award with no evidence that they were engaged in prevailing wage work on day 1 versus day 30. Maybe some of those plaintiffs were down the road, sitting on the corner just telling people you can't go down the street, and some of them were on the site. We don't know because plaintiffs failed to prove that. If the court has no further questions, I'll reserve my time for reply.
Thank you.
Good afternoon, Your Honors. Taylor Graham of Pelton Graham LLC for the plaintiffs' respondents.
Counsel, how do you construe both the prior decision below on the summary judgment and our determination of the appeal on the issue of the prevailing wage argument? And what's your basis for that?
I construe it as dispositive, Your Honor. I know Your Honor was on that panel, and we did argue about where those individuals were
That
standing.
was a determination on liability, was it not?
Correct.
So how, it seems to me that the argument focused against this is that there was not an evidentiary differentiation made between what's prevailing wage work and what's non-prevailing wage work. How did you satisfy the evidentiary, how did you establish as a matter of evidence what was prevailing wage work?
So that was done.
You're not contending, are you, that everything that was done constituted prevailing wage work?
Yes, we are, Your Honor. And that argument was made at summary judgment. And throughout this litigation, Judlow had argued that the entirety of plaintiff's work was flagging pedestrians. And that work is what the court determined was entitled to prevailing wage. They
And
made
that's
that
what the
argument.
court below held, that all of it was prevailing wage work.
Yes, exactly, Your Honor.
And how did we address that in our last appeal?
Exactly that way, that the work performed on the project. The court didn't have to go into the hours because the arguments were made in the briefing as to what hours were worked and what was entitled to prevailing wages or not. So defendants had taken the position that the entirety of the workday was flagging pedestrians and only a de minimis portion was additional work. But this court and the lower court rejected that argument, finding that the entirety of the work, flagging work, was entitled to prevailing wage. And defendants actually admitted that in their appeal on the summary judgment order, where, I quote, they say, "The Supreme Court found that respondents were entitled to prevailing wages for all of their time spent performing work on appellant's projects." That's their summary judgment appellant brief at page 7. That was clearly found by the lower court, and they appealed that decision to this court previously. This court affirmed the lower court's decision that all the work was entitled to prevailing wage. So we didn't need to rehash that at the damages hearing. And defendants didn't present any evidence or any witnesses at the damages hearing to counter plaintiff's theory of damages. We had an expert who determined what rates applied, and we used—
It's a question of just math.
Exactly. We used the certified payrolls. Your Honor, I know you were on the panel earlier for that summary judgment decision as well. We used the certified payrolls, which detailed all the time that was spent on the public works projects in that position, either flagger or crossing guard. That is what the determination was based on, the difference between the low wages that were paid and the prevailing wages that they should have been paid for those hours. The scope of the special referee's determination at the hearing was very limited. And Justice Borak of the trial court made that clear and said, these damages, contrary to what defendants are arguing, these damages are readily capable to be calculated based on the records that Judlow kept. If there was a need for testimony about where they were standing, which that had already been entered into the record at summary judgment, then I believe the court would have said that. So the special referee was fully within her hear and determine order to just determine what the damages were owed based on those records. And that's what she did. Defendants didn't mention their other arguments. I'm happy to answer any questions. I know this panel has a lot of experience with flagger cases, and I'm happy to go into any other issues.
Any other questions? Okay, thank you very much.
Okay, thank you, Your Honor.
So what is your answer to the argument made by your colleague that, in effect, that prior affirmance resolves the issue that you're raising today?
So our position, Your Honor, is that it didn't. It was a summary judgment decision on liability only. Justice Borick made clear in his prior orders that the question of the amount of damages would be a calculation to be done later, and referred it to a
But didn't you argue on the prior appeal that everything was being considered prevailing wages? And we affirmed that order.
The summary judgment decision on liability, and just to point the court to something that was said at the damages hearing, with respect to the amount of damages owed, there was a question as to whether or not the 731 rates of $94 an hour or the 1010 rates of $66 an hour could apply. And all the referee says at the hearing is she leaned toward the 731 rates. Plaintiff's own expert says depending on the nature of their work, either rate could apply. So plaintiff's own expert testifies that it depends on the nature of the work. You have to make a determination as to how to classify these employees based on the jobs they're doing on the job site. If they're down the road, then the wage is typically $14 to $19 an hour. What was awarded here is skilled trade wages that are given to people who are doing heavy excavation, underground work with absolutely no support for the fact that they ever did that work or that they should be entitled to it because they offered no proof as to where they were. And on the prior summary judgment decision and this court's decision on the appeal, the issue of liability is different than the issue of damages.
That's not how I read the decision. I mean, it sounds like you're saying that at sometimes some of these workers were doing crossing guard duties, and sometimes they were doing flagger duties. And of course, the flagger duties warranted the prevailing wages set forth in the booklet. So when our decision says plaintiff established entitlement to summary judgment through undisputed testimony about the nature of their flagger duties, which were consistent with the type of qualifying work identified by the controller as entitled to prevailing wages, namely the work, et cetera, in that decision. So that means that we found undisputed that Herman et al. Were doing flagger duties, and they were paid a lower rate. And therefore, the referee's job would really be to say, okay, let's go over their hours, determine how many hours they work in a particular shift, and just do the math. Why is that inconsistent with our decision?
Because the decision was that some of their work was consistent with that which would be entitled to prevailing wages. It wasn't that the damages hearing wasn't meant to be a rubber stamp where they just apply the calculation and plaintiffs are awarded for every hour worked. And Labor Law 220 only allows the prevailing wages for this specific type of work performed. It was plaintiff's burden to prove that they were entitled to these damages, whether it be $94 an hour, $66 an hour, or something else based on the nature of the tasks that they were performing.
Thank you.
Thank you.
Shudla Contracting versus City of New York.
Justice Kern, members of the court, may it please the court. My name is Henry Greenberg with Greenberg Traurig. I represent the Judlow plaintiffs in this action that was decided on a motion to dismiss, 49-page, granularly detailed amended complaint. The issue before you in this case is really quite simple. As voluminous as the contracts were, as complicated at face value it might seem, but it's really quite simple. There is a provision in the contract, I should say 3 pages of language, 10 paragraphs, 1286 to 1288, that describes minutely what a crossing guard does, a description of what it does, and how they are to be paid, And in highlighted letters, bold letters, on 1286 of the record, you will see it says that a crossing guard is not to be paid prevailing wage. Now, if there was any doubt that that meant what it said in bold letters and why it was bolded, before anyone ever submitted a bid, there was notice to bidders. Page 558. Not a lot here of notice to the bidders, except you'll see, paragraph 8, it reminds the bidders, before they submit a bid, that crossing guards are not paid a prevailing wage. What's the common sense of that? What's the logic of that? It's self-evident. Someone with a paddle that says go and stop should not be paid what a skilled laborer.
Counsel, let me ask you something. Where in
Please.
the complaint itself do you identify the provisions of the contract that were breached as opposed to what you're now arguing to us? Where, can you point to me the provisions in the contract itself? I mean, I'm sorry, in the complaint itself, that refer to which contractual provisions were breached?
I will do that, Justice Kern, but let me say, we have a breach of contract, cause of action. That's cause of action 7. This is a fraud case. This is a
I
misrepresentation.
know, but I'm
going to
asking
answer your
about the breach
question.
of contract right now. Because I
breach of-
thought you were arguing the breach of contract since you read.
One of 13, no.
Okay, so let's start with, well, let's ask about the breach of
Just
contract.
so I'm clear, Justice Kern, this is fraud. This is a misrepresentation. How do we know that? Because your decision in Herman was not based on a construction of the contract. You don't make any reference to the contract, nor did Justice Borak in his decision. Your decision was an extra contractual interpretation of 220, giving deference to 2 pieces of paper from 1998 and 2001.
Let me ask you something. If they made a mistake about the law of the city, or a misrepresentation about the law, is your argument that that would constitute a valid claim for fraud? If it was a misrepresentation about the law rather than a misrepresentation about the fact?
Oh, these are facts. This isn't law. This says don't pay them a prevailing wage. But if I might, this isn't Judlow's interpretation.
But isn't that a legal issue, whether or not the prevailing wage does or does not have to be paid under the law?
The contract says you don't have to pay them a prevailing wage. If I might, why is Herman, contrary to this, why is Herman, your decision, the 4 paragraphs that have spawned a cottage industry, that the entire construction industry is before you in this case today, the entire construction industry, a $44 million judgment, that's not a little judgment, that's an existential threat. Why are they here? Because for over a decade, Justice Kern, over a decade, not just the entire construction industry read this as it's meant to be read, the city of New York did, and saved themselves hundreds of millions of dollars. Why is it fraud? Because those memos you relied on, the 98, the 2001, by the way, not published on a website, not ever invoked by the city anywhere. You'll see it. It's an eternal document between the mayor's office and the controller's office. They were having a dispute. None of that. They were aware. The city was aware. None of that is in this contract. How do you know? Here's what your decision in Herman said, and here's what Justice Borak said. You said not that they were doing the work of a laborer. You said, Justice Borak said, because of their geographical location when they were doing crossing guard work, because of the close proximity to the construction site, they attended the same risks that a laborer would. Not that they were doing pipe fitting, but the risks. When you look at this, and I
want to ask you to wrap this up because your time's up. So
Yes, Your Honor.
just if you could wrap up the argument. Thank you. I would have let you wrap it up, but okay. Go ahead.
What's that? Oh,
I was going to let you finish the thought and wrap it up, but you looked like it was
here's-
starting a complicated.
Yes, here's what I urge you to look at. Not only the elaborate definition of what crossing guard does and how they get paid. If there was any doubt, there's a chart. And what does the chart show you when you read it? It shows you that people on the construction site, they don't get paid a prevailing wage. If they do crossing guard work on the construction site, they don't get paid a prevailing wage. That's A. But B and C, B, by the way, in close proximity to the construction site, they don't get paid a prevailing wage.
Thank you.
Thank you, Justice Garrett.
Ian Sinclair with the New York City Law Department for respondents. Supreme Court correctly dismissed plaintiff's complaint on two independent bases. The first is that plaintiffs are a sophisticated commercial entity. They deal with prevailing wage issues day in and day out, and the contract they entered unambiguously placed the risk of a prevailing wage mistake on them. Sections 5.1.
So isn't there some problem, though, that everybody, it sounds like everybody went into this contract with one understanding about whether the flagger work was prevailing wages, then all of a sudden everything changed. Why shouldn't the city have some liability for that, since the city also took the position that they did not have to pay that prevailing wage? And it turned out that that was an incorrect position. What is incorrect about the argument that the city should bear some liability for that mistake in its position?
Sure. Let me try to address a couple parts of that, or that in a couple of different points. The first is that I think there's a conflation between distance to the site and the duties being performed. This court relied on the controller's memoranda when it decided Herman. And the distinction in the controller's memoranda was between off-site vehicular and pedestrian, controlling vehicular and pedestrian traffic off-site, and other flagger duties, including direction that were performed on-site, including directing construction equipment and so forth. And so to the extent that the Herman decision was based on that distinction, that's the same distinction that's reflected in the specifications. It distinguishes, it says that the duties of a crossing guard or a flag person are directing vehicular and pedestrian traffic control. But then says a few lines down in the next subsection that distinct from that is directing construction equipment at the site or any laborer task. So it makes this very clear exception that distinguishes these two types of things. It's not based purely on distance. So and because the Herman plaintiffs alleged a broad array of tasks, including directing construction vehicles in and out of the site, standing at the construction zone barriers, and positioning safety barrels, these are things that fell into that second bucket.
What about Judd Law's argument that the industry on both sides all read this contract one way for a long time, and that the city and the controllers were going back and forth having a discussion that nobody else knew about, and all of a sudden they came out with this conclusion, which ended up putting an enormous amount, it's a $40-some million verdict that would go against them. So what about, was there some allegations of fraud that you can see in there for having these discussions and then all of a sudden interpreting these contracts a way that nobody had interpreted them before?
I mean, I think a couple of points. I think, firstly, that the discussions that were going back and forth preceded all of these contracts. And so from the city's perspective, this specification was the enactment of that. It wasn't misleading, trying to create some gap where plaintiffs would get stuck with this huge bill. But so there's that level. And to that extent, I think we believe that the work, that the finding in Herman was not inconsistent with the specification. So we don't think that there's an erroneous, we don't think that the specification is wrong on the law. To the extent that the industry was interpreting it differently, it seems that they were not necessarily using their workers in a way that was against the specification. It's very possible that everyone's crossing guards were actually at the end of the block or on the next block over, which it seems everyone agrees is not subject to prevailing wage labor.
Are you saying that this is fact-intensive and that the contract calls for the two examples in proximity to or away from, and then you have to look at the facts to determine the scope of the prevailing wage?
I think the city views the B and C people as people who are doing traffic control, vehicular and pedestrian traffic control off-site, and that the fact that this court's decision in Herman was not against that, to say, well, actually those people get prevailing wages anyway, even though they were doing crossing guard duties.
My point is it's the interpretation of the facts on the ground. So the contract itself would not necessarily lend itself to fraud, but an interpretation of how you use the laborer in the context within the prevailing wage rate.
Yes, I think that's correct. There has to be as I think everyone also agrees, there has to be some, you have to determine what the actual work is to be done. That's the whole basis for prevailing wage. So I don't think I finished addressing your point about the, so if I may just, like I say, there's a similar
Your
question.
time is up.
Okay, sorry.
You could wrap it up in
Oh,
one
yes.
sentence. if you-
Just to say that even if the city got it wrong, which we don't, we maintain that we don't, that comes back to the contract, which again and again says that it's the plaintiffs who are liable for a mistake. If an error in information does not preclude liability and plaintiffs agreed to indemnify the city for claims brought by workers for plaintiffs' failure to comply with the law. Thank you very much.
2 quick points. I think I just heard this.
How do you address that argument? That the contract clearly says when a determination is made that workers are entitled to more wages, that liability falls on the contractor, not on the city.
That relates to the workers' recourse. And we don't question that workers, if they can ultimately demonstrate, that's what they did.
But if their liability is as against the contractor, why should the city then ultimately be held responsible?
Because we must have recourse. If I might, just so we're dealing with reality, because I heard a lot of fiction. It wasn't the industry's interpretation, it was the city's for a decade. In bold letters, in notices to bidder. So let's not, oh, the city all along thought what you did in Herman was the law. They did have a piece of paper from 1998, barely readable internally.
No, counsel, we understand all that. So the question then is, if a mistake was made, who bears the responsibility? And how do you get around that contractual provision that says it's the contractor who bears the responsibility if a mistake is made in interpreting the law?
What it says, the actual language, is it does not preclude the ability of an employee to be paid the prevailing wage. That's all it says. And this is the first time they've actually engaged in the text of the language, but that's all it says. It doesn't say where is here, and if we're given the opportunity to take discovery, we will find out why they ignored that internal correspondence.
Right, but you only get discovery if the contract is ambiguous, obviously.
Respectfully, Your Honor, the language you're referring to does not say we are precluded from going after the city if the city committed fraud. If they wrote a contract that they knew exposed the industry to massive liability. And here's why you know, if I might, why you know.
One more sentence, because we've gone over already. You can wrap it up with one sentence. Your last sentence, go ahead.
The Department of Labor investigated them, and ultimately, when the Department of Labor found they were playing fast and loose with the prevailing wage laws on facts very similar to this, they indemnified Judlow and the rest of the industry.
Thank you.
Thank you, Justice Kern, Your Honors.
Plumbers Local Union versus New York City Department of Buildings.
Good afternoon, Your Honors. May it please the Court. Lauren Pelosi appearing for Local Plumbers Union Number 1. The construction codes are clear that only qualified welders...
Sorry, if you could speak up.
Sure, sorry. The construction codes are clear that only qualified welders can do dangerous gas pipe welding. A utility company can't turn on the gas until it gets approval to do so from the Department of Buildings. And a welder application to the department to turn on the gas includes essentially 2 things: welder IDs and welder qualifications. But we're here today because the department approves applications without looking at those application components, and the result is that 400 times a week it approves applications that don't have requisite documents.
Counsel, why don't we start with the issue of standing, since that is obviously a major issue in this case and a threshold issue, and why your client would have standing in this case to challenge these actions.
Sure, Your Honor. So the union is one of the most interested actors in this legislative scheme. The department's policy of not reviewing qualifications and stamping applications with approval indiscriminately undermines the union's mission, which is to provide safe gas work to the city. It's had that mission for
Doesn't
over a
everybody
century.
have that interest? Doesn't everybody want safe gas work? Why is Obviously, the union has a strong competitive interest in why it wants it to be complied with, but that's not enough for standing on our law. Why, in terms of just safety generally, why is their interest greater than anyone else's interest in having safe gas work performed?
The union has a strong organizational interest. The purpose of the union is to provide safe gas welding, and that organizational interest is protected by standing doctrine, where you can sue on the basis of harm and furtherance of that mission. The union spends millions of dollars every year to train qualified welders, and then the department makes it much more difficult for those welders to get jobs, and it makes it pointless, really, for the union to train welders to be qualified.
That sounds like competitive injury, what you're arguing now, which obviously is not a basis for standing under our law.
I think, Your Honor,
That they're going to have less work and less work to do, and they're not going to be trained as well. That all sounds like competitive injury.
I think, Your Honor, this case is a lot like Matter of Lawyers for Children. And so there, the organizational mission of the representation agency that represents children in foster care, they had standing to challenge a regulation that took children out of that system and diverted them away from where they would be entitled to that representation. And so the organization was harmed in its mission, which was to represent children, on the basis of that regulation, even though it was the policy that injured them in their mission.
Is there no one else other than the union that could challenge this rule? I mean, is there no one else other than the union that could challenge this rule? Couldn't a tenant or a property owner challenge the rule?
A tenant and a property owner, I think, could also challenge the rule, but I urge that the union has...
Who have a direct interest in this specific contract or in this specific job, unlike the union, which has a general and generic interest.
I think the union's interest is not general and generic in the sense that not only does it harm the mission, the policy also harms their ability to get jobs, it harms their ability to train welders, and it puts union members at a higher risk of physical harm. So yes, maybe others could
But they're
also
getting
sue.
jobs would not give you standing as a matter of public interest.
That's right, Your Honor. And so the
It's
union
a private
asserts...
economic interest. You wouldn't have standing to mandamus that, would you?
Right, Your Honor. So the union asserts that it has associational standing. It asserts organizational standing, associational standing, in addition to public interest standing. And so taking away union members' opportunity to get jobs is part of the union's associational standing. The department's policy that lets unqualified welders compete takes jobs from the union members and their qualified.
Can I stop you for a second? You're talking about competitive injury, and that the courts have said is not sufficient. Let's go back to what the standard is. Can you tell me what the public interest standard is greater than any other entity? And then secondly, what is the physical injury that your union members would suffer that's different and would set apart the union as vis-a-vis any other injured party?
Sure, Your Honor. So the union has public interest standing to protect the public interest, as you said, because that is its organizational mission.
Where does it say in your organizational mission that public safety is your mission? Can you read me where there is something specific in your mission statement that would give rise to this public interest? Thank you.
Your Honor, that's in the record at page 492. And
Can you just read it quickly? What does it say?
I don't have the text of it, Your Honor, so I apologize
Summarize
for
it,
that.
please.
It's that its mission recognizes that proper installation of gas is of the highest importance and that it provides safe gas work to the end of protecting public safety. So that's the public safety argument, Your Honor. In addition, union members are at a heightened risk of being exposed to catastrophic gas explosions. They're in and out of buildings every day.
Where is that within the record that would show that there is a direct rather than a speculative injury?
Sure, Your Honor. So in the record at 232, 228, and 496, union members are constantly working with an open flame on pipes installed by untrained welders, including while the gas is flowing. And so members of the public are not asked to be in and out of these construction zones. They're not asked to take an open flame to these pipes that have been welded by unqualified welders. That puts the union members at a much higher risk of this explosive gas type of injury. I see I'm out of time.
Thank you.
Thank you.
Thank you.
May it please the court, Jeremy Schwader for the Department of Buildings. I'd just like to make a few points on standing and a few points on the merits. So I think it's important to take these claims individually. Mandamus to review, mandamus to compel, declaratory. We're not going to bunch them all together. Mandamus to review, they haven't even tried to explain how they have standing to review each one of the gas approvals. That they don't even identify them, first of all, but they don't explain how each one causes them harm, and they can't do that. Secondly, on mandamus to review, goes to the merits. They haven't even identified what they want reviewed. This is not the way Article 78 actions are supposed to work when you're talking about mandamus to review. DOB is entirely left to guess at what it is they want us to undo and review. So, that's what Supreme Court found. That's totally right on the mandamus to review claims.
Which cause of action are you talking about? There's three.
Mandamus to review, right.
Which one was that?
You're talking about the merits and not about
Both standing for mandamus to review and the merits of mandamus to review. There's problems with standing, there's problems with the merits. Now I'll go on to mandamus to compel, which I think is what they've been talking about mostly, which is to compel them to, I guess, take action that's not part of any sort of regulation, to look behind the applications that are put in for gas approval. I think that's what they're asking for. So on standing, which I think is what you've been talking about, you can kind of take a step back here, because what they're really saying is they want the union to be kind of a super monitor of DOB's actions. They should be able to come in and say, yes, we're not a part of this application, but we are able to kind of look at everything you do, and when we don't like what you're doing, we can run to court and act as essentially a monitor of DOB. If they want that, that has to be something the city council gives them. They shouldn't go to court to kind of get that sort of result, which is why we say they're really seeking legislation through the judiciary here. On the merits of that, I think it's important to understand, everybody agrees that the word shall is what matters when you're talking about mandamus to compel, right? You're looking for a clear legal duty that applies. So
your argument go to that whole argument you just made, go to the standing issue, that's the reason why the law requires standing in the first instance, because someone can't just come in and say, I'm going to go monitor what a city agency does. There has to be some basis that they have a specific harm they're suffering that gives them a reason to intervene in any specific action.
Absolutely.
That's a standing argument.
That's a standing argument. I totally agree that on the mandamus, I'm taking these claims in order here. On the mandamus to compel, they don't have standing for that reason. But I want to address the merits on the mandamus to compel too, because Supreme Court did reach those as well and said that they couldn't state a claim. And the issue there is that you look at the word shall. So the provision that they now rely on, it's 406.6.2.1. And they use the word shall there, but the word shall is always to the licensed master plumber in the relevant way. A gas piping system shall not be energized prior to authorization. That's the licensed master plumber. Such authorization is demonstrated by issuance of certificate of approval of gas installation by the department, still on the licensed master plumber. The certificate shall not be issued prior to the completion of required inspections and tests. That's DOB, but that just talks about doing the required inspections and tests. So, and if you go to other provisions that we've cited in our brief that use the word shall to instruct what DOB has to do, you can see the city council has been very clear when it wants to instruct DOB what actions it has to take. The inspection shall be performed after all work authorized.
So, I mean, we know that the laws were changed after a couple of disasters in, I think, 2014 and 2015, where down on the Lower East Side and up in Harlem, there were some buildings that blew up. People were injured, a lot of property damage, and that's when the city council came up with some new rules. So who would have standing to say that you have to comply with the rules? I mean, or do you just have to comply with the rules, and if you don't, then somebody brings an action? I mean, how do we get to this?
When you're talking about mandamus to compel, right, we're talking about a very narrow type of claim under Article 78 that's rarely recognized, and it's usually saying you have to decide something that you haven't decided, especially when you're talking about permitting, right? It's something like, you're sitting on my application, make a decision. That's what you are compelled to do, right? Because you look at what is actually happening. There is nothing here that compels DOB. I've just read the provision that compels them to do what they're asking. So in terms of standing, it's going to be somebody who's made the application and saying, make a
Give me
decision.
an application, or you denied my application, I should have gotten it, or something
Or
like that.
deny, if you're talking about mandamus to compel, it's deny or grant it. Take action, do that, right? And that's where you usually see mandamus to compel come out. It's not do things that the statute doesn't actually say you need to do to look behind. There's just nothing they can look to on the merits on mandamus to compel that shows a clear legal duty to DOB here. And the declaratory judgment action, it really fails with standing on the same reasons. On the merits, they're asking the court to declare that DOB has to do something that's not a right that is instructed by law, and that's really their problem, which is, they have standing issues, they have merits issues. Supreme Court reached both those correctly. Unless there's any further questions, thank you.
Thank you very much.
Thank you, Your Honor. 2 points in response to opposing counsel here. I want to be very clear. The union seeks 3 forms of relief. One would be a simple declaration that the department has to review welder qualifications. The department comes outright and admits that it doesn't even review the qualifications that are supposed to be part of this application.
How would that be implemented? Let's say we say, okay, the Department of Buildings has to follow its own rules. What would then happen practically in the real world? Would you be able to come and say, hey, they're not following the rules, they're violated, and seek contempt? I mean, is that how it would work?
Presumably, Your Honor, the department would comply with the court order
I
telling
mean, normally
to do review.
departments do comply with their rules. I mean, that's what they're set up to do. So I'm just not sure how this would play out in the real world exactly. Other than you bringing a contempt motion, that they're violating the declaratory judgment that they comply with their rules.
Right, Your Honor.
Is that what you're envisioning?
I think it's important here that the department has a policy, a continuing.
No. I'm trying to understand just on a very practical basis what you think is going to happen if you're successful in this lawsuit. That you're going to get to oversee what they're doing in each application and how they're handling. Like, what would your role be if you were successful in this lawsuit?
I think the declaration would just say that the department needs to do a review, and it would be up to the department to comply with that order.
So we would say, department, do the review, and now they have to do the review because we ordered it, and that would be the end of it?
That's right, Your Honor, but there's also 2 other forms of relief.
No, the time's up. But
Thank you.
And we're familiar with the other form. That was my question. Thank you. Nicholas Industries versus NASD. Go ahead.
Good afternoon, Your Honors. Andrew Muchmore, counsel for Plaintiff Appellant Nicholas Industries. With respect to our appeal, we believe the trial court conflated the standard for willful exaggeration of lien under lien law 39.
What specifically did NASD do, there's a notice of claim provision in the contract, right?
Yes, Your Honor.
That requires you to file it, I think it's within 7 days. What specifically did NASD do which prevented you from complying with that notice of claim requirement?
So for the cross appeal, we believe there is both an affidavit and 3 items of documentary evidence establishing a course of conduct that deviated from the subcontract's change order approval process. First, the affidavit provides that our client met with both NASD and the city and that was instructed to submit a change order at the end. This was corroborated by an email from...
Did that prevent you from submitting a notice of claim?
Not prevented, but there was a course of conduct that deviated for that. For instance, with the removal of the trees, the contractor provided $3,000 for tree removal, but the actual quantity of trees was much higher. Our client submitted an invoice and was paid over $40,000 for tree removal.
But you knew that the contract required that there be a notice of claim, and you saw things weren't happening or things weren't being done exactly the way you expected. Why didn't you comply with that contractual provision and file the notice of claim?
The court's case law recognizes the patterns on the ground often deviate from what's written in a contract. And in an ideal world, contractors would strictly comply with every item of minutia in a lengthy contract. In the real world, there is often deviation, and that supports relief from the literal text of the contract when there is substantial evidence raising a tribal fact issue as to equitable estoppel and
Don't we have
course
a
of
number
conduct.
of cases that say that the requirements for notices of claim are to be strictly enforced? And unless there's some very direct evidence that that's a bar to the claim, and that we've in fact dismissed many claims, and the Court of Appeals has dismissed many claims on the ground that the notice of claim requirement. So then the fundamental question becomes, what prevented you from filing a notice of claim? It's not what prevented you from performing the work or for getting paid. What prevented you? So what is it? And I know my colleague asked that. What prevented you from filing a notice of claim once you knew there was a dispute, and whether or not they were giving you a hard time about paying for it? That wouldn't have prevented you from filing the notice. So what did?
So we maintain that's not the standard, that they were not, that the standard is not that you were prevented from giving a notice of claim, but whether there was a course of conduct that persistently deviated from that. And in fact,
Counsel, I think you need to go back to your own record, because the principle of the plaintiff made it clear that, well, he thought they were on constructive notice because of the invoices sent for the 48,000 cubic feet of dirt that they excavated above the original change order 25. That's one point. But he also said that he had a specific employee that was charged with turning over to Nasty all the information they needed to be able to justify paying their fee or the cost of the contract. And he specifically said in the record, which wasn't really refuted by any principle of Nasty, that they were hindered in being able, in that process, to give the paperwork, because every time they said, "Did you get our paperwork?" they kept saying, "We didn't get it yet," or "We did," that kind of hindering the process. And that's the equitable estoppel argument you made, correct?
correct. The email from NASD's principal didn't, it indicated that they were putting together the change order for submission to DEC. It didn't indicate they were waiting further information from Nicholas Industries for that. They've been provided the dumping tickets. They provided all the information that they had requested, and our client's understanding was the ball was in their court.
Well, if they said they didn't get it or they didn't, and you say they did, that would be a dispute about whether or not you had actually complied with the requirements. But that wouldn't stop you. I mean, if you said you made the you put in what was necessary, they said you didn't, we'd have to figure out, that would be a factual dispute, but that wouldn't stop you. I mean, if they said we didn't get it, you said yes we did, you still could do it. There might be a dispute later down the line. I've been having a hard time trying to figure out what, and I know everybody asked this, but I'm still having a hard time figuring out what stopped you from complying with the requirements of the contract, which really, in so many cases, we have these cases all the time, require very strict compliance with the terms about how many days you have to make these to file the notices of claim. And I just can't figure out what was stopping you. Even if they weren't paying you, that you could litigate later, but at least you had done what you were supposed to do in the first instance. Wasn't that like a condition precedent?
So first, Article 10 didn't explicitly reference condition precedent. It wasn't condition precedent type language in the subcontract. But secondly, we don't believe the standard for equitable estoppel or course of conduct requires being physically impossible for you to strictly comply with the contract, only that you be lulled into a sense of complacency and belief by the other party that you've done everything necessary for them to package and submit that change order.
What was it that sort of lured you into that complacency?
One was the pattern and practice with respect to the trees. There was a prior change order where they did not strictly adhere to these provisions. Two was an email from NASD saying that they were submitting the package to DDC and weren't requesting anything further. And then three was their submission on a regular basis of the dumping tickets to NASD, and NASD's acceptance of those and not giving a further indication that it was looking for something further to compile and put together its change order to DDC.
Thank you.
Good afternoon, Your Honor. It pleases the court. My name is Adam Cole. I represent NASD.
Let me ask you a question. So your argument is that because there was no notice of claim, they should be barred from seeking payment. But how would they even know to file a notice of claim if they're repeatedly being told that they will be paid, that things will happen, the change order will be submitted? How would they know that there's a problem that they need to file a notice of claim about?
The notice of claim provision requires notice within a period of time after the service provided. It is true, at least there's a
But it's
question.
based on your belief that you're not going to be paid in the normal.
No, that's not correct. There are two different things going on here. Let's just take the dirt, for example. Okay, the dirt was a change order, something that needed to be changed. It was a provision in the contract for a certain amount of dirt to be moved, right? If that change order was not being submitted, there may have been some kind of equitable defense to a change order not being submitted. But once it wasn't submitted, that's where you get to the second part of the contract. Change order provision is Section 6. Section 10 is a separate part of the contract that says, if you're not getting the relief you want, if you're not getting the
Payment?
the relief you want, you need to file a very specific notice of claim. And it is a condition precedent. It's not a provision
Does
like,
it say if a change order is not submitted when it should be, that you have to file a notice of claim?
yes, absolutely, because that's when the event occurs that requires the notice of claim. The
You're
note,
saying once they asked for a change order to go through and you didn't submit it, that's when the notice of claim should have been submitted?
at
Even if
latest.
you kept assuring them that it was going to be submitted?
At latest. But you can't, but that's exactly what the Court of Appeals has said. Actions, negligence, or bad faith, or those types of issues does not overcome the requirement of a condition proceeding. Condition proceedings, contractual condition proceedings that refer to a waiver of a claim. It's very specific. Refer to a waiver of a claim is a condition proceeding that must be strenuously followed, otherwise you waive the claim.
Is there any difference between the notice of claim provisions in your contract versus a contract you have with the city? Or is it
Yes,
track the same
I
language?
believe there is a difference, but that's part of the reason why the notice of claim provision is so.
What significance should we give to the fact that the city contract has an estoppel provision and the contract that you have doesn't have that estoppel provision? Doesn't that support the argument that an estoppel argument could be made, that you should be stopped from asserting
No.
the lack of a notice of claim?
No, that, I would agree with you on that if it was an issue of a breach of contract. For example, let's assume there was some duty under the contract to have submitted a change order. But estoppel, specifically, the equitable principle of estoppel and other equitable principles under the AHA case in the Court of Appeals, specifically does not apply in the context of a notice of claim. And to
How does the lack of a notice of claim interplay with the whole lien law? Separate and apart from the exaggeration issue, what's the interplay between the lack of a notice of claim and being able to pursue your lien law claim?
one of the arguments we did make that the trial court did not get into was the fact that there was a lack of a notice of claim meant that there was no right to a recovery of damages that could be liened, okay? That was something that we said was that prevented the lien from being valid.
Sorry, was what?
That's something that we said in the trial court that we said was a piece that made the lien invalid
But it's
because
a separate analysis. Isn't it a separate analysis? Whether or not they can pursue, so even if we found ultimately that there was no valid contract claim because they didn't file a notice of claim, they could still proceed on their lien law claim. They wouldn't be precluded just by virtue of not having filed a notice of claim. Is that correct?
Well, we would argue, again, we would argue that, we would probably make that argument later on, but the judge in this particular circumstance in the summary judgment did not even address that. We did make that
Let's say
argument.
we find that there was no willful exaggeration, they could proceed with a lien law claim.
Mm-hmm.
What impact would a decision that there was no timely notice of claim have on their proceeding with a lien law?
My understanding is that at that point, they would need to, the burden on the plaintiff would be to prove the validity of the lien and the amount of the lien.
But that's a separate issue from the...
Separate issue, it's not
and
something that's,
The lack of a notice of claim has no specific impact on the lien law claim.
it may, because
It may, but we don't know that yet.
That's correct, that's not part of this right now.
Not part of the argument.
Counsel, I have a very simple question. If Nasty had properly submitted a change order reflecting the work, which I didn't see seriously disputed, that they moved 48,000 cubic feet of dirt, as opposed to being limited to the 11,000, the original DDC change order 25. If they had done that, as Mr. Nguyen in writing to them on 1113 of the record, if they had done that, would you agree with me that that would moot the whole obligation under 10.2 of the subcontractor? Yes or no?
I would not agree with you.
Why is that?
It might,
Okay, it might.
it might provide, well, let me finish, because I disagree with Your Honor respectfully. It might provide a response to whether or not the work done under the change order was approved, because that is a contractual provision, okay? But the notice of claim provision is separate and is very specific and requires very specific things to occur. I hear you. I understand that it seems a little bit odd, but that's the way the law is. That's the law. The notice of claim provision is required to be specifically adhered to, whereas certain other provisions of the contract that are contractual only may be waived or may be subject to estoppel or.
Can I ask one more question? Justice Kern asked you that there was a contract between you and the city, and then
Yes, I wanted to finish that.
and NASD. And if there was no estoppel provision in your contract between the two of you, does your contract in any place incorporate the contract and the provisions that you had with the city?
Yes, in fact, the contract specifically incorporates, and the plaintiff signed off on this and testified to it, it's in the record, that it in fact incorporated the prime contract into the subcontract. But if I may answer your question, Justice Kern?
Quickly.
There is a provision in the prime contract for purposes of notices of claim, and in that prime contract has certain dispute resolution types of provisions that are used by the city or part of that contract to try to resolve the issue. Now remember, when dirt is moved and a claim is or a change order is submitted or requested by NASD, and there's a violation of that, then it goes to, and then Nicholas has the ability to make a claim, and then it goes into this provision to NASD. NASD submits it to the city then can use its dispute resolution procedure to determine whether or not, in fact, 48,000 tons of dirt was actually moved.
Thank you.
And that's it. Thank you.
Thank you.
Like to highlight two practical realities and how they tie into the law. One, the work that was performed was roughly 4 times the scope of work that was originally contracted. There was no surprises here. There was an ongoing dialogue between DDC, NASD, and Nicholas regarding the additional scope that was being performed, and Nicholas performed as it was instructed to. The second point is the relationship that exists between a general contractor and a subcontractor on a public works project. The contractor has a direct contract with the city, is bound to every one of those terms, not just those that are incorporated by reference, and they are the ones that maintain the relationship and submit change orders and accommodate the city's requests. The subcontractor relies entirely on the contractor to provide information about how to proceed, and is a functional matter, submits what is requested, provides notice.
All right, but once your client did not receive a change order as requested, why wasn't it the obligation of your client under the contract to then submit a notice of claim?
Again, I go back to the equitable estoppel argument based on it being lulled into a sense of complacency. At that point, this had been going on for years. Everyone was aware of this. It was well past the 7-day period referenced in the notice of claim provision. During that period, it was relying on what it was told by NASD that it was
They didn't do
submitting.
anything to stop you.
We do not maintain we were prevented.
They didn't do anything to prevent you from filing a notice of claim.
We do not, correct. But I also don't believe that's the standard. I believe the standard is inducement of reliance. And I believe that there was a pattern on the ground that induced our client into a sense of reliance.
Thank you.
Thank you.
Bailey versus 2732 Bainbridge Associates.
Good afternoon, Your Honors. May it please the Court. Jason Steinberg representing Appellant. Ms. Bailey. I think first we can all agree that the Court should not have denied summary judgment in its entirety based upon an issue of fact of comparative fault, because in 2018, Rodriguez versus City of New York specifically held that a plaintiff does not have to prove the absence of comparative
No,
fault.
and I don't think that's what the court did. I think the court denied summary judgment because it found that plaintiff didn't establish that defendant had actual or constructive notice of a leak as a matter of law, which is a separate issue and would be a basis for denying summary judgment.
Well, and that's incorrect also.
But why isn't there an issue of fact as to the notice issue, as to this particular leak?
Because the superintendent testified when he went to the apartment and was interacting with my client, he had already placed the bag over the hole. That's what he said. He put a bag over there because there was a leak that had occurred 2 days earlier that the plumber was sent to fix. Specifically testified to that, and then said the plumber, in doing these repairs, left the piece in the sink or something underneath the sink when he was doing these repairs, and that caused a third leak, which my client apprised him of, and he was there, and that's when all this happened. It was around the time of the accident. So everything that occurred in that apartment above with this broken pipe all happened before my client's accident, and there's nothing to dispute that. The superintendent's testimony that I don't remember when I went doesn't refute my client's testimony that within a month before the accident, this hole was progressively worsening up until the point of the time of the accident when the whole thing collapsed and there was water all over the floor, which caused the accident. There was a repair order, well, a work order, that was generated, or at least given to us by the defendant. Super says, I don't know whose writing that is, that's by form. But nonetheless, it says on the repair order, or the work order from a day after the accident, that the ceiling has to be plastered, which I think we can all infer from that there's clearly damage to the ceiling. And again, the super's testimony, his only recollection of interacting with my client is when there was a third leak from the apartment above.
There's no question as to whether or not the defendant was told about the leak before the accident?
I'm sorry, say it again?
There's no question as to whether or not the defendant was told about the leak before the accident?
Not only told about it, but they knew the source of it. They knew the source of the leak, and all they did was put a paper bag or some kind of plastic bag over it because the whole ceiling was saturated, and they didn't want to fix it entirely because the tenant in the unit above had vacated the apartment. So the idea was to wait until they did all the repairs to that unit. And in doing so, the condition got worse in my client's apartment below, and ultimately to the point where her accident occurred. On top of that, this is a res ipsa case. You have a ceiling that collapsed. Ceilings don't collapse in the absence of negligence. There's at least 2 cases in my brief that say that. Mejia versus the Transit Authority First Department case, and then a case called Joppa versus Starrett City. Ceilings don't collapse ordinarily in the absence of negligence. The second issue, exclusive control. The superintendent testified as to the source of the only leaks that he recalled. And the source of those leaks were piping in the infrastructure. Owner has exclusive control over that. This isn't a toilet overflow. That's not what happened here. So the tenant is not in control.
She also didn't have the ceiling fall on her. This is not a case where the ceiling collapsed and the ceiling fell on her. This is a case where she slipped on water on the floor. So it's not exactly a ceiling collapse case, it's a slip on the floor case.
Well, the slipping coming from the broken ceiling and the leak.
This isn't a case where the ceiling collapsed and it hit her head,
That's correct.
which is the traditional ceiling collapse type case.
Well,
There's no way to avoid, if you come into a room and a ceiling collapsed on you, there's no way you could avoid that. Where if there's water on the floor, there is potentially a way you could avoid that.
well, if
It's not the same scenario exactly.
it's not exactly the same, but as far as proximate cause is concerned, it doesn't matter. Because proximate cause, we all know, we don't have to foresee the exact manner in which an accident occurs.
Yeah, but you're advocating re ipsa, where the plaintiff would have no role in light of what happened to her. But in fact, she was aware of this whole, at least a month before the accident. You agree?
I agree with that.
Okay, and going into the bathroom where she said the lighting conditions, it was daylight, and most people tend to look where they're going, and she waltzed right in claiming she was looking at the toilet versus at the floor. So that's, as my colleague pointed out, this isn't a re ipsa type case.
Well, the third element of contributory negligence on behalf of the plaintiff doesn't apply to what she sees or doesn't see. It only applies to whether or not she actually contributed to the accident occurring. In other words, contributing to the ceiling collapsing. The cases are very clear on that, and I can only defer you, I'm thinking offhand, Ezard, E-Z-Z-A-R-D, that's the elevator case, and the court defined that third element of comparative fault. Contributory negligence, meaning the plaintiff actually contribute to the damage that happened. Not that she didn't see where she was going, that doesn't matter.
Thank you.
It's still comparative fault, yeah.
Thank you.
Okay, thank you.
Good afternoon, Your Honors, and may it please the court. Ross Frisha for defendant respondent. I just want to address this kind of confusion or mischaracterization of the facts here. Number one, there is no testimony or evidence anywhere in the record that the plaintiff informed the defendant of the leak at any time before her accident.
What's all the stuff he's talking about with the garbage bag? Was that a prior incident?
I'm sorry, Your Honor?
But opposing counsel was talking about the garbage bag over the ceiling. Was that from a prior incident?
The record's not clear to that, honestly, and actually, the record supports a different version of events, which is that all of this, from the time that the superintendent was first informed of the leak, happened after her accident, and I'm going to tell you why. You have the testimony of the superintendent that said that on the same day that he was informed of the leak, he went to the plaintiff's apartment. That's in the record at 226 and 227. He called a plumber to fix that leak on the same day, which was emanating from a hole in the bathtub pipe. That's in the record 230, 231. Then he put the bag over the ceiling that same day. The next day, the super received another call from the plaintiff saying that there was another leak, and he went there and fixed that leak the same day. The work order that the plaintiff was talking about, which is in the record at 281, has two dates. It has a date of March 23rd and March 25th, right? And it's about fixing the ceiling. With respect to that, the superintendent testified that the ceiling was repaired 2 days after he was informed of the leak, and the work order says, and if the superintendent testified that he created that work order from the moment he started working there, 255 in the record. So with that, that elicits that that particular leak, again, from the date on the work order, March 23rd, versus the date of the plaintiff's accident, March 22nd, that happened afterward. And at the very...
The plaintiff didn't testify one way or another about when she told him about the leak.
That's absolutely correct, Your Honor. She was never asked that
She was
question.
silent, and there's no affidavit from her addressing that issue.
Right. The only thing that she testifies was that she knew of the leak for a month.
To make a long story short, you're saying that you only found out about the leak subsequent to the act. Is that correct?
That's a version of events, at least, that the record supports, and it raises a tribal issue of fact.
Is there anything in the record that would indicate, as my colleague just mentioned, that there was a complaint prior to the accident, let's say within the 30 days prior to the accident?
No, Your Honor. There is no testimony or evidence to that effect. And then with Res Ipsa, like Your Honor pointed out, this isn't a case where the ceiling fell on the plaintiff. She was walking into the bathroom in the morning, again, being full aware of the leak, and slipped on the water and debris on the floor.
So you would say there's a possibility of comparative fault here?
Yes. Yes, Your Honor. So that would be the third prong of the Res Ipsa analysis. And there's also an issue of fact as to whether the tenants were still in the apartment 5D. And if there are no further questions, Your Honor, I'll reserve my time.
Thank you.
Thank you.
On pages 245 to 247 of the record, the superintendent said 2 days before he met with my client, 2 days before. The work order is prepared on the 23rd. That means 2 days before is the 21st, which is the day before my client's accident. That's when he knew about the issue with the plumber, and the plumber caused the dangerous condition. That's all I have to say about that. The only thing I can say about the comparative fault, you get out of bed in the morning, you go into your bathroom, you walk in, you just get up in the morning, you go into the bathroom, you walk in, and you slip and fall, you don't know anything's on the floor. I don't think that's
Counsel, was the
comparative.
lights on or not?
Oh, sorry.
Was the lights on when she stepped into the bathroom?
I think she was going in and turning it on at the same time, and then slipped, so it was not on, yeah.
I thought the testimony is that she only saw it afterwards because the lights were off. Maybe I'm mistaking the testimony. I thought that she didn't.
I'm not sure. I thought it was, she walked in, turned the light on, and slipped. That's my understanding.
Okay, could be.
I'm not going to belabor over comparative fault. You can't deny an entire summary judgment motion, though, based on that ground. That's all. Okay.
Thank you very much. Teton versus Ruckus 85 Corp.
Good morning, Your Honors. May it please, good afternoon, Your Honors. May it please the court, my name is Robert Sokolsky. I represent the plaintiff appellant Yvette Georges Deaton. This case concerns a cooperative apartment in a very, very small 4-unit cooperative apartment building. It was a cooperative apartment that was set up by the plaintiff's father. When the father set it up, it was set up requiring a 75% vote for most actions taken by the group, and also was equally restrictive with how the co-op could charge.
Counsel, we're familiar with the record. Why don't you address the issue of collateral estoppel, since that's the major issue that we have to determine in this case, whether or not collateral estoppel should or should not apply?
Yes, Your Honor. It's black letter law that a determination made on a TRO, temporary restraining order, or preliminary injunction is not entitled to collateral estoppel
So what
effect.
happens, because sometimes, since the court's required to determine the likelihood of success on a preliminary injunction motion, and to do that, courts often make determinative findings in their preliminary injunction decisions because they do that when they're evaluating likelihood of success. If a court were to make such a determinative finding in its preliminary injunction, is your argument still that that would not be entitled to collateral estoppel effect?
Yes, because there's not a full and fair opportunity before that decision's made. There's no discovery taken, and there's no, and like in this case, there's no evidentiary hearing.
Well, what about if it's based on the court's review of documentary evidence, which it finds to be dispositive? It makes a determination that there's no possibility of success on a claim. Would that still not get collateral estoppel effect? I know there's not a lot of case law on this topic. There's some, but not a lot.
It depends. I don't know that there's any documents against a complaint on a motion to dismiss. There's very few cases that are going to be determined on documents only, especially when the plaintiff, as in here, is and has asserted what she asserted in this complaint, that she was singled out, that there's been 11 years of bad blood and bad litigation in this building, and that there is a motive behind what they were doing that would take it out of the business judgment rule. And
Well, that's your challenge to the wrongful termination.
Right.
Based on objectionable conduct.
Yes.
Let's just finish off your earlier thought in terms of the dismissal of the 2022 action because she failed to serve a complaint. Can we all agree under the law that that's not collateral estoppel?
Right. Well,
that wasn't a decision on the merits, which would not preclude her from going forward here, correct?
Right, because a dismissal of an action for failure to serve a complaint is not on the merits.
Okay.
It's not on the merits decision. It does not raise the prior denial of a TRO into a decision on the merits. It's simply a dismissal of that action that was not finally determined.
Let's move on to a more important issue here. Would you agree on this record that Rabin Walker, who was the who bought the shares at auction and had no relationship with Ruckus and put in a legitimate good faith bid, that case law would compel that you can't simply unwind that? Would you agree? Or you obviously disagree, but
not in this case. The UCC permits a sale of shares if there's a default, but the UCC does not define default. Where is default defined? It's in the lease agreement. So if the co-op did something that makes a notice to cure equivocal or unclear, doesn't give you directions of what to do, then the lease, which describes default in you did something wrong, you got a notice and you didn't cure it, now you're in default, right? Default never happened. It doesn't happen unless you get a clear and unequivocal notice of what you did wrong and what you can do to cure it. In all cases here, the conduct that the tenant has been accused of is capable of cure. The lease says.
I'm going to ask you to expand on that in your rebuttal. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Dan Goldstein of Smith, Gambrell & Russell, LLP, for Respondent Ruckus 85 Corp. To respond to some of the things counsel for plaintiff was saying, actually, before the lower court reached the collateral estoppel issue, the lower court started with this court's holding an Atlas MF mezzanine, and based on that court's holding, dismissed the first two causes of action for declaratory and injunctive relief. The Atlas case is squarely on point to this case.
You're talking now about the sale, that it's binding and it can't be undone at this point.
That's right, that's right. So the first two claims in this action are to unwind the sale.
But if they wrongfully terminated the lease or wrongfully asserted arrears for this several, I added about $232,000 in arrears, arguably, as a basis for the sale under the UCC 9, that's the basis for it. But if she sought a declaration that those arrears were wrongfully calculated, there would be hear me out, would you agree that there could be a basis for damages against Ruckus for the sale of those shares?
What Atlas holds and what Judge Leibovitz held is that if there was a defective process with the UCC auction, that the plaintiff can go for money damages, can sue for money damages.
But you can't undo the sale because there's a good faith purchaser, and that's the end of it under Atlas.
So the action should go forward as against Ruckus, shouldn't it?
The action is going forward against Ruckus. Her money damages claims are.
But the causes of action, that would dismiss should be restored, should they not be?
We're asking about the collateral estoppel claims.
So.
Because the judge below held that some of the claims were dismissed on the basis of collateral estoppel, and if we disagree about that, then those claims are not going to go forward also.
The lower court dismissed the first two claims for injunctive relief and declaratory relief because you can't unwind the sale based on Atlas. The court then held the claims for conversion and unjust enrichment are dismissed because of collateral estoppel.
Right, so if we find that collateral estoppel does not apply, those claims are then going to go forward. So you're arguing collateral estoppel, right?
I'm arguing both. I'm arguing.
All right, so let me ask you about collateral estoppel, because assuming you're successful on that the sale cannot be unwound, the next issue is collateral estoppel. The case law that exists, and again, there's not a lot of it, does seem to support the principle that a decision that's made on a preliminary injunction or provisional remedy, or by not going forward with serving a complaint, is not entitled to collateral estoppel effect because it's not a full and fair determination. I think the two primary cases were Coin Match and Huguenot. Why aren't those cases dispositive on the issue of collateral estoppel not being applicable here?
Well, the cases, Your Honor, that I would say are controlling here are not those respectfully.
The ones you cited all have to do with a default. A default is obviously a very different situation. Why would we follow the line of cases having to do with defaults when there's another line of cases specifically having to do with provisional remedies, and there is no default in this case? Those seem more on point to our situation.
Respectfully, Your Honor, I think the default case, well, specifically these cases, the Canat case, the Lattimore case, and the Abadabi case, are more on point than the cases that were cited by plaintiff and I'll explain.
Wasn't the determinations made on a preliminary injunction motion as opposed to a default that we're talking about here?
In those cases that are cited by the plaintiff, they're really just general propositions, just citation after citation. A preliminary injunction is not a
right, but they clearly hold that a preliminary injunction determination, which is exactly what we have here, is not a determination on the merits because there's not a full and fair opportunity to be heard, particularly here where there was no hearing.
There was absolutely a full and fair opportunity to be heard, and that's why the cases that we've cited are more on point. As Judge Leibovitz cited in the order.
Is logical, is it not, that a preliminary injunction denial should not have collateral estoppel effect?
It depends on the circumstances. This is a nuanced case. This is an exception to that general rule, and Judge Leibovitz cited to cases that are exceptions to the rule.
The only cases he cited, I haven't seen, and maybe you can show us one, I haven't seen any case that holds in a preliminary injunction situation, a provisional remedy situation, that should be given collateral estoppel as opposed to the line of cases you're referring to, which are default cases. Are there any cases where the courts have upheld, given collateral estoppel effect to a determination made on a preliminary injunction motion?
In the cases that we cite, there are decisions that are made on motions for relief in the middle of the case that then the party who brought the case failed to continue prosecuting. So decisions on motions for personal jurisdiction dismissal.
But personal jurisdiction is different than a provisional remedy. Personal jurisdiction is a dispositive determination of the case. If you don't have personal jurisdiction, there's no way to go forward with the case. Whereas if you lose a provisional remedy decision, you can still go forward with your case, you just don't get the provisional remedy.
What Judge Leibovitz did, and again, I think he was very correct in doing it this way, he didn't hold, because I'm finding a likelihood of success, because Judge Getz found a likelihood of success, I'm barring your claim. What he said is that because Judge Getz found the UCC process complied with the UCC, the lease was properly terminated, the findings that he made on the motion, those findings are what are res judicata, not the holding on the preliminary injunction motion.
Though obviously it's not res judicata because there's no final determination. So we're only talking about collateral estoppel, but thank you.
Then the court, yes, but then the plaintiff had the full and fair opportunity to, and let the case lapse.
Thank you.
Good afternoon, Your Honors. May it please the Court, Jeffrey Klarsfeld for Rabin Walker, the successful purchaser.
So you're only here on that very limited issue of whether we should unwind the sale and whether Atlas versus Mezzanine is dispositive on that issue.
For the most part, the only causes of action in the complaint against my client were the first and the second, which were the injunction and declaratory relief, and there was a sixth cause of action for unjust enrichment, which Judge Leibovitz dismissed against my client because it wasn't opposed in my motion and it wasn't even briefed in this court. I think it was abandoned. Those were the only three causes of action against my client. So that's what my brief is limited to. And I think Your Honors hit the point on Atlas MF, of which three of you were on the decision. So unless you have any other questions, I'll rest on that in my brief.
Any questions? Okay, thank you very
Judge.
much.
Your Honors, the Atlas case is not like this case in that the plaintiff's complaint here is not that the defendant cooperative did something wrong in noticing the sale. It's not her only claim. There are a bunch of claims, but her claim to unwind the sale isn't because of a UCC defect. It's because a condition precedent to holding a UCC sale, that is a default, never happened under the lease.
I know we have the author of the decision here in Atlas, since it was Justice Kapnick who wrote the decision, but it does seem to me that that decision has a broader holding, which is that once the sale takes place and there's a good faith purchaser, you are limited to an action for damages, whatever the reason was. Once the good faith purchasers comes into play, then your only remedy is damages and you can no longer unwind the sale. So the fact that something happened at one stage versus another stage, I'm not sure how that would impact that reasoning.
Right, but in this case, it wasn't even the plaintiff's shares to the unit that were sold. They were reissued. She didn't surrender her shares. The collateral, your financing agreement or your collateral are the actual shares, right?
But again, I really don't think that matters. I mean, pretty much this case has been followed for a number of years, and you're dealing with. I mean, you're dealing with the purchaser for good faith. I mean, that's really the person that's would be damaged in this situation. They bought. There's no claim that they didn't buy. We're not a purchaser for good faith. They bought it. They have it. Your damages claims, I get.
Yes, Your Honor, but you have to think about what did they buy? They didn't buy the plaintiff's shares. They bought shares that were reissued by the co-op under the very same lease that governs their conduct. So if they don't show a default under the lease, like for example, if you had any tenant in a co-op and they didn't default, and the co-op thought that they did, and they just reissued the shares and lease and sold it, and the person was away, and the UCC notices, you're going to say that you can't unwind that sale?
We understand your argument.
Thank you.
Thank you.
Have a good afternoon, Your Honor.
You too. State of New York versus Kenneth W.
Good afternoon. May it please the court. My name is Naomi Weinstein on behalf of appellant Kenneth W., Mental Hygiene Legal Service. The trial court erred here in finding that Kenneth W. has a mental abnormality. There are two prongs in order to show that the state had to prove by clear and convincing evidence, which they did not do here. First, they have to show that Kenneth W. has a condition that predisposes him to commit sex offenses. And the second prong is that they have to show that he has serious difficulty controlling such sex offending conduct. Here, the only diagnoses before the court were antisocial personality disorder and substance use disorder, namely.
But isn't that what the experts determined, that the confluence of these disorders together gave him that to predispose to commit the crimes he historically committed? And that the fact that he was institutionalized and wasn't able to, drink alcohol freely or take marijuana freely or any of the other substances that caused him to do the crime that he did. Why wasn't that a fair finding for why he needed to continue to be institutionalized?
So first, Your Honor, the state's expert, yes, did testify that antisocial personality disorder and substance use did confound. However, Mr. W. had his own expert testify, Dr. Haddon, who explained that when you have a diagnosis of ASPD, the comorbidity rates are upwards of 90% to have an equal substance use disorder. And more importantly, there was no link that the higher courts have recognized that's necessary to show. When you have a non-dentist...
Isn't this an issue of first impression, actually?
Yes, it is.
The issue of whether this is sufficient?
Yes, that's correct, Your Honor. There's no appellate authority about whether ASPD plus substance use is enough. Of course, there is a Court of Appeals case, Shannon S., which says you don't need any condition at all, but the Court of Appeals made clear in Donald D.D. that ASPD alone is not enough. And what's important in this particular case, even the trial court noted...
You have more than ASPD here, don't you?
Well, here there's...
You have the alcohol use disorder and the cannabis use disorder.
Yes, Your Honor, but again, there was no link made between those diagnoses.
Why isn't there was clearly evidence presented that there was a link between these disorders and the ASPD diagnosis that caused these events to happen, that it was while he was under these influences that he was much more prone to commit these offenses. And they argued, at least, that there was a direct link between his use of these substances and the behavior that's the subject of this proceeding.
So the specific testimony below was just general testimony that alcohol use could lead as a disinhibit.
Didn't Mr. W. himself admit at some time that the taking of the alcohol sort of was involved when he committed some of these incidents, and that it did affect him and sort of take away his restraint? I mean, didn't he himself admit some of that?
So those are some realizations that Mr. W. made during substance use treatment, which he underwent in prison, and sex offender treatment. But the evidence that alcohol played a role in his 2016 felony sex offense is completely unclear.
Was he under the influence of alcohol when he attempted to rape the 16-year-old girl?
I believe you're referring to the misdemeanor assault case that from 2010. And actually, in that case, both the state doctors admitted there was absolutely no evidence that he drank alcohol, that it played any role, or that cannabis.
But there was evidence that he drank heavily before committing the qualifying sexual assault in this case.
So regarding the 2000, right, and the incident offense, Your Honor, he did admit to the state's doctor that he was drinking earlier before the offense. But again,
substantial amount of alcohol.
I don't remember if it was...
He said he consumed a bottle of liquor, I think.
Yes, Your Honor. And again, but
And
when
he said, didn't he, that his inhibitions are diminished? His ability to control himself is diminished when he's under the influence of these substances.
I don't believe those were his exact words, but that was the
in sum and
expert's testimony.
substance.
And Your Honor, that goes to the insight that he has. And the fact that he has been incarcerated doesn't mean that he doesn't have access to alcohol, doesn't mean that he doesn't have access to drugs. And again, there was no link made regarding the 2016 offenses that he was even drinking before them. And Dr. Ives even admitted regarding the cannabis use that it really seemed to calm him down. That's how he described it. And again, when you're talking about
Let me ask you, in terms, if we were to affirm this order, what is the way forward for Mr. W? For W, is there a certain number of years in which you can make an application to be released that circumstances have changed?
There are built-in periodic reviews. However, he's looking at lifetime civil commitment. And again, Article 10 is only meant for the most dangerous sex offenders. And Mr. W is not the most dangerous sex offender. Here, there was no clear and convincing evidence that his particular ASPD, which the trial court itself admitted was a weak...
Why do you say that he's not a dangerous sex offender? I mean, we are dealing with 3 sexual offenses, aren't we?
Your Honor, there are 2 felony sex offenses and 1 misdemeanor assault case, but not all recidivist offenders, right, are meant to be managed under Article 10. The state has to prove that they have a mental abnormality. And we submit, even if this court finds that he has a mental abnormality, that the state did not prove by clear and convincing evidence that he is a dangerous sex offender, the most dangerous.
Let you address that on rebuttal since your time is up. Thank you.
Thank you, Your Honors. May it please the court. Cleland Wilson for the state. The respondent's own expert, Dr. Haddon, testified that the respondent is an aggressive individual with poor impulse control, that his sex offenses are very clearly driven by his severe antisocial personality traits, and that his alcohol abuse is a significant contributor in his offending conduct. Supreme Court's mental abnormality finding should be affirmed based on those admissions alone. The respondent tries to argue against his conclusion by disputing Supreme Court's finding that there's an obvious direct connection between his mental health disorder.
So ASPD by itself would not be enough to support this order. So the additions that you have here is that he has the alcohol use disorder and a cannabis use disorder. So what is it about, don't those offenses have to be tied to sexual misconduct in order to support that which you're arguing for?
They do, Your Honor.
And how does the evidence get you to that here?
Well, so what I would say, I would just step back briefly to the Dennis K. case from the Court of Appeals. There, what the court was dealing with was ASPD plus borderline personality disorder. Neither of those was an obviously sexual disorder, but the court held that combining the two, because of the particular facts of the borderline personality disorder there, that was sufficient to support a link between the diagnoses and the individual's sexual offenses. The same thing is true here, although ASPD and substance abuse disorders, neither of those are directly sexual offenses, sexual diagnoses. When you take the two together on the particular facts of this case, they have combined together, as Justice Shulman suggested, they have combined in a confluence to create this predisposition to commit sex crimes. And we know that because he admitted that he consumed alcohol before some of the offenses against his daughter, and that was why he lost control and committed those offenses. And he admitted that he consumed a bottle of liquor before he committed the violent sexual assault that led to this proceeding here. And so we have direct links between his substance abuse and the offenses that led to this proceeding. And so we do have a link here, just as there was a link in the Dennis K. case. And so we think we have made the predisposition showing that the Court of Appeals requires. And I don't think this is, I think it is a matter of first impression for this court. This court hasn't specifically ruled on the issue of ASPD plus substance use disorder, but I would refer the court to the Philip Q case out of the 4th Department and to the Francisco R case out of the 2nd Department. Those are in our briefs. Those address very similar issues of ASPD.
Did they actually come to that holding, though, that the alcohol abuse and substance abuse disorder combined with ASPD was enough to qualify?
That's my recollection of those cases. I haven't looked at them this morning or today, but that was my recollection of those cases. Yes, they do make that holding. They had moderate psychopathic traits, but as I think is clear from the record here, psychopathy is a sort of stronger version of ASPD, so I think the same analysis applies in this case as well. And even if you think those cases aren't directly on point, I think that Dennis K. is on point insofar as it supplies the analysis here. What you have to do is look at his diagnosis, see if there is a link between what he's been diagnosed with and the crimes that he has committed, and the evidence here does support that. If we can turn then to the second step of the analysis, the respondent's mental health disorders also cause him to have serious difficulty controlling his unlawful sexual conduct. Again, his antisocial personality disorder leaves him with poor impulse control. His substance abuse eliminates whatever inhibitions he might otherwise have. He doesn't have internal controls that would normally inhibit unlawful sexual conduct. He doesn't feel remorse for his past sex crimes. He doesn't care for the needs of others. He suffers cognitive distortions that prevent him from stopping himself from committing further sex crimes. For example, he didn't view anything wrong with the crimes he committed against his daughter. He thought the violent sexual assault that led to this proceeding was in fact a consensual act. He doesn't have the internal controls, and he hasn't completed sex offender treatment in a way that would allow him to develop self-control either. Although he went through 2 treatment programs that only addressed the abuse of his daughter, he participated in those programs only formulaically. He didn't derive any benefit from it, it's clear from the record. And Dr. Haddon, in fact, admitted that he does not have constructive plans, does not express a desire to make positive changes in his life. And if he's not going to make positive changes in his life, he's not going to have derived a benefit from the sex offender treatment, and is not going to be able to stop himself from offending down the line if he were released into the community.
Thank you.
I just want to briefly respond to what my co-counsel argued regarding ASPD plus psychopathy. That is, psychopathy is generally found, as the state's expert testified in this case, as a more severe form, which Mr. W does not have. He does not have any form of psychopathy. He does not have a form of severe ASPD. The trial court in this published probable cause hearing in this case questioned whether he even meets the criteria for antisocial personality disorder because of the lack of evidence of conduct disorder before age 15. And regarding the comments that Mr. W has made in sex offender treatment about some of his cognitive distortions, those reflect behaviors that he used to have, not that he currently has. And that goes exactly to the danger that Chief Justice Wilson mentioned in the dissent of, I think it's Donald Dede, I'm sorry. But basically that, when the conundrum that these clients face, things that they say in sex offender treatment are used against them, and whether or not they participate. But here the bottom line is Mr. W completed sex offender treatment twice. He's never been diagnosed with a deviant sexual interest. He displayed no acting out behavior in terms of any sort of issues controlling his sex offending behavior in prison against female corrections officers, against female treatment providers, and therefore the state failed to prove that he has a mental abnormality. Thank you.
Thank you. Thoroughbird Grand versus M. Melnick.
Good afternoon, Your Honors. May it please the Court. Ira Schulman from Shepard Mullen with my partner, Cesar Pereira. I think all lawyers like to say they have complex construction cases. I don't think this is that complex, this appeal, for 2 reasons. One, when a contractor assigns its right to a surety, as Melnick did here to federal, it loses its right to pursue those claims.
So isn't this somewhat of an unusual case, though? Because the cases that you're talking about are cases where there's a complete assignment. They assign their rights and they don't have any further role in the contract. But here, in addition to the assignment, there's also a takeover agreement and a completion agreement, which specifically say that there's a reservation of certain rights, that the only thing being assigned is the right to payment. So doesn't the facts of this particular case, and they continue doing work on the project, doesn't that distinguish that from the more broad line of cases which just generally hold that once the surety takes over, that's it, there's no more claim?
I don't think so. and I'll tell you why.
Okay, go ahead.
If we look at the assignment, which is on 608 of the record, Melnick agrees Federal has, by subrogation and assignment, all rights, title, and interest in and to any funds paid by the owner under the contract or under the takeover agreement. That's very, very
That's
clear.
about receipt of payment, though, right?
Sorry?
All of the provisions have to do with receipt of payment, and they're not bringing this action to recover the payment. They're bringing this action based, or the counterclaims based on other claims having to do with the construction contract, not having to do with receipt of payment. So it appears that one at least could argue that the only thing they've assigned is the right to receipt of payment.
I don't think that, respectfully, I don't believe your reading, Your Honor, is consistent with what is said in paragraph 14, because it talks about funds to be paid under the contract or under the takeover agreement. Melnick further agrees that Federal is not a fiduciary of Melnick. And here we have a situation where...
But it says, I'm looking at the language that I thought was germane, Federal has succeeded to all of Melnick's rights to payment and compensation under the contract.
Federal.
Right.
Yes.
So that goes to payment. That's what it succeeded to.
The issue...
Good question. I'm not
the issue
telling you
that's
my
being
position.
conflating here, respectfully, they're bringing these lien claims based on liens. And you can't have a lien claim unless you have a right to payment. And that's where we believe Justice Gomez got it wrong the second time round.
That was exactly the issue in the other case today. Go ahead.
The issue Justice Gomez respectfully think got wrong, he got tied up with the issue of the lien fund. The issue of the lien fund here is utterly irrelevant. You only talk about a lien fund when you get to the issue of whether or not you can recover something on your lien, whether there's going to be a fund available. But when you have now totally assigned your rights to payment under these agreements, you have no rights to file a lien. If you have no rights to file a lien, there's no right under any of the lien fund, just as a second step you don't get to.
Under your scenario, no one can file a lien because Federal had lost it on the last appeal that we had, and now you're telling me that Melnick can't do it as well.
Your Honor, that's exactly correct, and this should not come as
No remedy whatsoever.
No, they have remedies. They have contract remedies against Federal, who they have their...
Talk about lien holder remedies.
No, they don't.
So no one would have a lien anymore. I would...
Your Honor, that is just what this court determined years ago in the Paddock boat case. You decided when you had a public-private partnership, there could be no lien rights. This should not come as a surprise, and nor is it any different here. Sometimes when you assign your rights away, you lose your lien rights. And that's what happened here. The law does not call to account saying, well, you preserve your lien rights if you happen to assign them to an entity that doesn't have them. That's not...
Can you answer my colleague's question? Where does it say in the assignment or anywhere else that the lien rights were assigned or extinguished?
Well, a lien right is a right to a payment. The only purpose you're filing a lien for is to get paid. There's no independent right. What are the purposes of is a lien on a project?
Then why would there be the language in the completion agreement where Melnick reaffirmed its obligations under the takeover agreement, and the takeover agreement provided that expressly provided therein, the parties reserve their rights under the construction contract, bonds, takeover agreement? That's a suggestion that there are other rights other than the right to payment, which are still being reserved. So what does that language mean? You're saying it's meaningless.
May I continue?
You can answer my question.
Yeah, well, I'm just saying I have to...
Yeah, no, I just asked a question. You can answer it.
When you're looking in paragraph 15 on page 608, there is no reference to the contract. There's no reference to the contract in paragraph 15 of the assignment. Thank you. I reserve.
Good afternoon, Your Honors. May it please the Court. Michael Glansman with Smith, Gambrell, and Russell for the respondent, M. Melnick, Co. and Inc.
So how should we interpret this assignment to the surety? Why doesn't it obviate their right to bring these counterclaims?
Sure.
It's right.
All the the language in the completion agreement did was insert federal as the surety into the payment process. So before federal stepped in as the surety, the completing surety, the payment process was Thoroughbird as owner, Melnick as contractor, subcontractors. Of course, in that typical scenario, all the subcontractors that perform work have lien rights, and the general contractor has lien rights. The only difference here is that in the takeover scenario, you have Thoroughbird as owner, federal receives the payments from Thoroughbird. Thoroughbird then pays dollar for the construction work performed by Melnick to Melnick, and then the funds flow to the subs.
So what about counsel's argument that that you don't have a right to file a lien? We already decided, I was on the bench, that you couldn't, that federal can't file a lien because they're not a contractor. But if a lien is theoretically, so you get paid, should Melnick have the right to file a lien in this particular scenario?
Yes. Under the lien law, Melnick has an absolute right to file a lien.
Even with this
payment flow provision. It's just like a
Does it have a
subcontract.
right as a subcontractor? You're saying it's no longer the contractor's shoes, but it's still the subcontractor's shoes? Is that your argument?
It's similar to the subcontractor having the right to lien. It's the same situation. And I was going to start with the prior decision. Thoroughbird is here taking a completely contrary, in fact, the opposite position that it was taking a year ago. A year ago, it came before this court and argued that federal had no lien rights because it was a surety, and the surety hired the completing contractor, Melnick. This court agreed and held federal had no lien rights and held that federal hired Melnick as the completing contractor. Now, after that decision came down, the argument is presented, no. Melnick has no lien rights because they were assigned to federal. It's irreconcilable to try to insulate a private project. Council mentioned a PPP, a private public partnership. That's not what this is. This is a private construction project, and I'm not aware of any private construction project in the history of New York post-lien law that is unlienable, and that's what they're arguing for here. So, and with respect to the language, and I think Your Honor was touching on this, nowhere in this record will you find an assignment of a claim or a waiver or assignment of a lien right. It's not here. The lower court correctly interpreted the plain language that just said it was an assignment, a subrogation. That's the order of payment. It just means that it goes from owner to federal to contractor and then to subcontractors. The subs and the contractors always have lien rights. And the last thing I'll touch on here is even if the court were to adopt the interpretation of Thoroughbird and agree that in this completion agreement, Melnick assigned all of its rights, even though the words rights aren't used, and claims, even though that's not used, and lien rights, even though that's not there. And
Counsel, they can't assign lien rights because federal is a surety.
That's right. So, but even if we tried to assign our lien rights, okay, Section 34 of the lien law is very clear. Any contractual provision, any arrangement that divests a contractor performing work for the improvement of the developer's property of its lien right is unenforceable. The language doesn't say it, but if it did, it would be unenforceable. And with respect to claims, and this will be my last point, if we had assigned all of our claims, again, claims is not there, and we reserved our rights a dozen times in both the takeover agreement and the completion agreement, but if we had assigned our claims, federal assigned them back to us. They said, just for belt and suspenders, to try to avoid all of this, if you think that Melnick assigned all of their claims to us, no, we're assigning them all back so that everybody is clear. There's no dispute. Melnick owns the claims, and Melnick has always had a lien right.
Thank you.
The reference that counsel just made to the assigning back is not in the record, and we would challenge if it were that there was absolutely no
We
consideration.
will not consider that in our determination.
Thank you. Two other things, Your Honor. Number one, in this situation, Melnick assigned their money rights first and then filed their liens. That's the problem. They could have filed their liens initially while they were still the contractor, but they didn't. They chose to file the liens after they had assigned their rights on all the money rights to federal. That's where his argument falls off the rails. Number two, in this situation where he says lien law 34 has nothing to do with this. Contractors waive lien rights all the time when they get money. It's not an issue of a public policy issue here. There's no public policy at stake. Lastly, just to refresh your honor's recollection, I know Justice Kapnick was on the bench at this point. Melnick was chosen as a completion contractor by federal as one of the remedies under the payment bond that came into play when Melnick was defaulted for cause. They have no privity with Thoroughbird. There are no contractual privity claims with Thoroughbird. They never had it. They gave it away. Thank you very much.
People versus Dwight Furrett.
Good afternoon, Rachel Lindy from the Office of the Appellate Defender on behalf of Dwight Furrett. The suppression evidence did not establish that the police had probable cause to arrest Dwight Furrett. At the time that Mr. Furrett was arrested, the testimony indicated that police knew only that Mr. Furrett had spoken with someone who later made a drug sale and that he left before any sale occurred. But conduct that is just as susceptible to an innocent interpretation as it is to one of criminal conduct is too equivocal to be the basis for arrest. And this court and the Court of Appeals precedent is clear that merely talking to someone is quintessential equivocal conduct. So,
Isn't my understanding that the ghosts communicating information to have the respective detectives follow and specific information with a specific description of your client at a specific place, the totality of that information suggests that there was probable cause for the arrest?
it is correct that a description was conveyed. At that time, they were still, that was only at that point, the investigation was ongoing. Mr. Furrett was only in conversation with someone. He left, and then later, there was a positive buy signal made just as to the co-defendant. And so all that was known at the time that Mr. Furrett was arrested was that he had spoken with someone who then later participated in a drug sale. And it is inconsistent with this court's precedent, with the Court of Appeals precedent, that without any indicia of criminality or participation in a drug sale, that would be enough to establish probable cause. And that's because all that we have here from that conversation is something that is just as susceptible of an innocent interpretation. There is no indication that they were not just, they weren't talking about the weather or asked him the time. There is nothing more here to indicate that Mr. Furrett participated in that drug sale. And that's not to say that it is not a possible inference, but insofar as the suppression hearing testimony also allowed for these innocent interpretations, that was not enough to establish probable cause. And to decide otherwise would be to criminalize mere guilt by association. It is, again, well established that mere presence near a drug transaction is not enough to establish probable cause, nor is mere conversation. That's all we have here. We don't have any exchange of objects. We don't have any other indicia of criminality. We don't have really anything at all beyond this conversation and a later positive buy just as to the co-defendant. If that is enough to also implicate Mr. Furrett here, then that is guilt by association, which the Court of Appeals has made clear has no place in our jurisprudence. And briefly turning to the appeal waiver here is invalid, and this court is therefore able to reach the suppression decision, grant suppression, and dismiss the indictment. The appeal waiver is invalid for a few reasons. Initially, the colloquy was deficient, where the the plea court at no point indicated that any rights survived the appeal waiver. This court has held time and again that failure to make any indication that rights survive the waiver renders the colloquy deficient. That's especially the case here, where there was no written waiver whatsoever to supplement or clarify the deficient oral colloquy, and there's no record indication whatsoever that Mr. Ferret consulted counsel or had the opportunity to consult with counsel about the appeal waiver. Quite to the contrary, the record indicates that he did not speak with counsel at any point during the duration of the plea proceedings, and as such, the totality of the circumstances indicate that the appeal waiver was invalid, and thus this court may reverse the suppression decision below and dismiss the indictment. And I will reserve my time for rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Hunter Barron for the people. I did want to start with the appellate waiver. To my knowledge, no decision by this court has held that failure to mention the residual rights that survive the waiver automatically invalidate it. The main point is whether the court said that there was an absolute bar to any appeal during the waiver, and that didn't happen in this case.
I'm more interested in your take, the communication between the ghosts who observed the co-defendant and the defendant in their interactions, and then signaling to the respective detective to follow, et cetera, and the descriptions. How that all supported probable cause.
Sure. So, so here we're really applying the fellow officer rule. That's what the court applied below. And under the fellow officer rule, there's no obligation for one officer to communicate to another all the information they have in order to establish probable cause. Here, the only question is whether the arresting officer, Detective Irizarry, was able to infer from the communications he received from the undercover officers that they had observed the defendant here participate in a drug transaction, or that he was being directed to effectuate an arrest. And here, Detective Irizarry said that he was part of the Chase Auto Squad in this particular case, which means it was his job to apprehend the suspects. And the undercover officers communicated that a description, a location, and the primary officer also directed him to follow that the individual that they had identified. And from that, the only reasonable inference that Detective Irizarry could make is that they were directing him to arrest that individual.
Is that enough without having received a positive by transmission? I mean, isn't that kind of a thin amount of evidence here?
Well, it was perfectly natural for the positive. It was mentioned the positive by, just not that defendant in association with the positive by. But as the court explained below, it was perfectly natural for the ghost undercover not to mention defendant in that positive by signal, because of course he had walked away by that point and the hand-to-hand transaction was with the co-defendant. I think the only ambiguity that is possibly introduced there with the lack of positive by signal for defendant is whether the drug transaction was still ongoing or had occurred before that point. But ultimately here, that's immaterial because Detective Irizarry waited until he received that positive by signal to effectuate the arrest of defendant here. So unless your honors have any questions about the remaining issues, that's ineffective assistance or deprivation of counsel.
Thank you.
Okay, thank you.
Thank you. Just 2 quick points. The first, I'd just like to make a quick correction to respondents' comment regarding the waiver. This court on multiple occasions this year has ruled that failure to indicate that any rights survive an appeal waiver invalidates a waiver. We can point to this court's decisions in People v. McCrae and People v. Amparo, which are both cited in our reply briefs. And secondly, returning to the suppression matter, again, the positive by signal was only for the co-defendant, and at that point,
why would the undercover had transmitted the defendant's description if he wasn't involved in the sale?
Again, at the point that according to the arresting officer's testimony, at the point that that description was transmitted, the investigation was ongoing. Mr. Ferret then left. The arresting officer followed him through Washington Square Park and arrested him when he heard a positive buy for just the co-defendant, which again gives no more information than that which was already there as to Mr. Ferret, which was only that he had spoken with someone who had participated in a drug sale, and thus it provided no more than mere guilt by association. For this reason, thank you. We ask that you dismiss.
Epps versus Barfield.
Louis Lombardi on behalf of defendant. This is a slip and fall case on steps. The plaintiff cannot win. The summary judgment should have been granted on the simple fact is the plaintiff doesn't know what caused his fall. On the record on R29, he states, I don't even know what foot I was using and where it went. So this is a case just based on speculation. And speculation is not enough.
Didn't plaintiff testify that he found the cracked steps?
They found,
second
allegedly they found a little nodule, I guess I would call it, on a step. There's no indication of how deep it is or if
He
there's
also said the
rise.
steps were cracked, and the pictures
show
tell
you
1,000 words.
The pictures show you peeling paint.
No, it's beyond that. I mean, you didn't put anything to counter the plaintiff's expert, did you?
Excuse me?
You didn't put anything in the record to counter the expert
Well, the expert
affirmation.
opinion was not, the expert was not.
It was 1 month after the accident. He
Yeah,
saw
yeah,
the
but the
steps.
expert-
And he describes
Right.
a multitude of violations, not just simply peeling paint.
Right, but the expert opinion should have never been admitted because he never shared it with us.
And when
The
you look at-
discovery order by the court specifically says to share your expert opinion.
Yeah, but
They
you
never
got,
did it.
you got it with the summary judgment motion, and you were able to look at it, you were able to reply to it, and we usually allow that.
We had no chance to get our own expert based on.
But when you look at the picture, it really, it's very hard not to say that there's a potential defect in these steps that could have caused the fall. I mean,
Well, the pictures that you're looking at, as I said, what we're really looking at is peeling paint. As for the defect, again, if there's a
but it looks
defect,
like more than peeling paint on the picture.
if there's a defect there, the person has to say that defect caused his fall. Just because there's something here
He
like.
claimed that the crack in the stairway caused him to fall.
No, he did not, because he does not know where he stepped. He says, I don't know where I stepped or with what foot. So now we're into a guessing game. Their expert brings up handrails. Again, there's nothing brought in about handrails, but he brings it up. Why? I don't know. The plaintiff himself had said he had used those steps before and never had an issue. So do we have any kind of knowledge?
He doesn't say it was on the second step?
That's what they're saying, yes. It's the second step. There's a little nodule, but he has said in the past that he has used those steps and there was no issues. So therefore,
But
there is
that doesn't
no.
preclude a claim as a matter of law that it's steps you've used before and you didn't fall before? That doesn't bar you from bringing a claim.
It doesn't show any constructive or actual knowledge
Well,
of the event, of the exit.
The expert did say that based upon the condition of the steps when he observed them, which I believe was not too far after the accident, that the dangerous conditions of the steps had existed for a sufficient period of time to give you constructive notice. Now, that's what he said, so even if
But
he
that
said
conflicts
no,
with
there's
his, that
issue of
conflicts
fact.
with his own, it conflicts with his own client. His client said there's nothing wrong with the steps. He's used them multiple times.
I don't think they
So
said-
what the expert is doing, and what the problem with it is by them not sharing that with us, what he's doing is throwing as much as he can out there and see what
Counsel, this isn't a 3101D situation. The expert affidavit was attached to their papers in opposition to your motion. You had a full and fair opportunity. You could have moved to the court, I just got this information, I need a little more time to get an affidavit in reply. You could have done that. It wasn't an ambush.
It is an ambush because the court said you have to supply this by such and such a date. They never did. They only supplied it in their papers in response to our summary judgment motion.
Can I shift it a little bit? Doesn't your own client, Barrington Field, who is the president and super, admit on page 85 through 86, there were cracks all over the tread on the second step? Didn't your client admit that?
No, he did not.
Look at
Not from
pages
my reading.
85 through 86.
Well, I don't have the record in front of you, but no.
That's my
He
record.
said his testimony is he lives there. Whenever he saw that there was a problem, he would fix it.
No. When counsel showed him the picture, he asked him to look at the photo. I remember which one it was. And he asked him, are there cracks all over the steps? He said, yes.
I don't think
Look at pages 85 through 86.
I don't have him in front of me, Your Honor.
Thank you.
Okay.
Good afternoon again, Your Honors. Jason Steinberg, I represent the respondent. Judge Hagley, you are correct. The defense witness did
I thought I read the
testify when
record.
he was showing the photographs. There's cracks all over here. If I saw those, I would have repaired them.
I
So
mean,
that
the
is.
photograph, it doesn't look like peeling paint.
No, it's cracks. There's an indentation on the second step. My client specifically testified as
There's a
Judge.
crack running all the way across the step.
Correct. Not only that, the handrail was too far from when he was walking down the stairs. He also said that. My client said the handrail was too far, unable to grab it. But before we even get to my expert, as Judge Tuitt correctly decided, they didn't affirmatively establish that the steps were not dangerous. That was their obligation in summary judgment, not to just argue it wasn't dangerous, because that's my opinion as an attorney. They needed facts to substantiate that, maybe an expert like we got, or photographs, measurements, anything to establish affirmatively that the steps were not dangerous. So we didn't really have to submit anything in
It
opposition.
was their motion for summary judgment.
Absolutely.
So they had the obligation to make a prima facie case that they didn't create it. They had no constructive or actual notice.
They have
Seems
to
that the expert in opposition at least raised an issue of fact, and I understand what you're saying, but there are cases that say as long as you can get it, I know you would have liked to have it earlier, but sometimes that doesn't happen. You got the expert's report, you had an opportunity to respond to it. I don't think you made your prima facie case, so we don't even really have to spend so much time looking at your
I don't need to repeat anything.
evidence, although we have been discussing it.
All right. Thank you very much, Your Honors.
I have nothing further.
Thank you.